Mr. Chairman, members of the committee, my name is Robert Parker. I'm a lawyer, managing partner of the Taipei office of Kirkwood, Kaplan, Rustin, and Vecchi, and president this year of the American Chamber of Commerce in Taipei. I've lived in Taiwan now for about 3 years. Our Chamber of Commerce has a membership of over 500. It includes all of the major American investors in Taiwan. And the membership for which I speak consists of the people who live and work in Taiwan who actually carry on the ongoing commercial relationship between the United States and the Republic of China. They have a perspective that perhaps on this panel is unique in that regard, and they represent a number of years of accumulated first-hand knowledge of the situation in Taiwan. The experience that we have had there has given most of us a great deal of affection for the people of Taiwan and respect for its government. But we, as an organization, and I personally am not here today to speak on their behalf, although we care deeply about them, we are an organization which exists to protect and advance the interests of the American economic presence in Taiwan. And my purpose in being with you today is to point out those areas in which I feel that the normalization policy and the omnibus legislation proposed by the administration is deficient, and to offer concrete suggestions for curing those deficiencies. Part of doing business and doing it successfully is having certainty. Business thrives on certainty. And no element of certainty is more important than one's physical security. And so obtaining a strong security resolution from this committee, from the Congress, is indeed important. There's been a great deal of comment about that already, and I don't want to devote a lot of my comments to it, except to react to something that the chairman, Senator Church, said just before he departed. He inquired, I believe, of Senator Danforth whether the language of the security treaty, which refers to an armed attack on the territory of either party, was adequate language. And I'd like to submit that that can be improved upon. For example, I think that a naval blockade of Taiwan is a very real threat in terms of what military action might be taken against Taiwan by the PRC. More so, I would submit, than an amphibious assault on Taiwan itself. And I don't believe that that would be covered by language that talks about an armed attack on the territory of Taiwan. The second element that I believe is important has already been acknowledged by the committee, and that is the sale of adequate and sufficiently sophisticated defensive weapons that will allow Taiwan to maintain the technological edge that it must have in order to maintain a sense of security against the numerical superiority of the PRC. I would agree that it's unlikely that there will be an armed attack by the PRC against Taiwan. I think the threat of economic coercion is much greater and therefore more dangerous. And I believe it's essential for the Congress to provide some protection, some meaningful protection for Taiwan against the threat of economic coercion. I believe that there is evidence that such economic coercion already exists, that there is a selective boycott at least already in effect. There is anti-boycott legislation on the books, of course, but there are a couple of problems with it. One is that the administration has not shown a real inclination to enforce this kind of legislation for the protection of Taiwan. Quite to the contrary, in fact. The other is that the penalties of the anti-boycott legislation are aimed directly at American companies. And as a Chamber of Commerce, I have to say that I'm not entirely comfortable with that solution. We would like to see something where the penalties are aimed at the real culprit, in this case the PRC. We'd also like to see an assurance that OPIC insurance, political risk insurance, is going to continue to be available for American investments in Taiwan. But most particularly, we believe that meaningful protection would be provided if the Congress makes clear provision now and places the PRC on notice that if there is economic coercion against Taiwan, or military coercion, that they will lose all of those things that they hope to gain in the relationship with the United States. Ex-Im Bank credits, MFN status, access to technology, and et cetera. Finally, and most importantly from our standpoint, is the failure of the administration bill to provide an adequate legal framework for the ongoing commercial and trade relationships between Taiwan and the United States. A number of the pragmatic problems that would inevitably arise from normalization were anticipated by our chamber several years ago. And for at least the past 3 years, we have been posing a series of specific questions to the administration, to the White House, to the National Security Advisor, the Secretaries of State, the Taiwan desk officers, and we've never received a responsive answer. After normalization, we still were not able to receive an answer, and we were always deferred to the omnibus legislation. Wait till that comes out, that will take care of everything. Well, now we have it in hand, and we find out that from the standpoint of private interests, business interests between the United States and Taiwan, its language is ambiguous, its approach is frequently naive, and it is wholly inadequate to meet the needs of the ongoing commercial and trade relationships between the United States and Taiwan. I could give a number of examples for that, and I know that time is not quite adequate to do so. So let me quickly summarize those principles which we believe are important to cure those deficiencies in the omnibus bill as proposed by the administration. One would be to approach a solution to the fundamental flaw of the administration bill, which is a failure to provide any link between the term the people on Taiwan and the government of the Republic of China. I'm not a diplomat, and I won't speak to the question of whether you can conduct non-official official relations through the kind of instrumentalities that the government is proposing, that the administration is proposing, and whether you can sufficiently carry out governmental business by referring to the people on Taiwan. But if you don't at least define that term to make it clear that you're talking about the government on Taiwan, then I can assure you that it's not adequate legal basis for the private and commercial relationships that are intended to continue between our two countries. The administration has said that the treaties and executive agreements in effect on December 31st of last year, other than the Mutual Defense Treaty, which will end on January 1st, 1980, are intended to continue in effect. But the omnibus legislation does not specifically say that, and it should. There should be provision for that. It should also be clear that agreements between the United States and Taiwan, both those agreements existing on December 31st, 1978, and ones to be entered into in the future, will have the force of law. That is, that they will have the same status in law as a treaty or an executive agreement. Because if they're only private contracts between a non-governmental instrumentality here and one in Taiwan, then what binding effect do they have on the courts of the United States when issues come to be litigated, as they almost certainly will? Finally, in the area of agreements, the way in which this administration handled the termination of the Mutual Defense Treaty, in spite of the Stone Dole resolution, with so little prior notice and no consultation with the Congress, gives us as businessmen, all of whom are dependent to some extent on the treaties and executive agreements between the United States and Taiwan, great concern and insecurity as to whether a similar tactic might be used later on with respect to some of those agreements, such as the FCN, Friendship, Commerce, and Navigation Treaty, which are so important to continuing the commercial relationships between the U.S. and Taiwan. And on that basis, we would propose that the Congress include in this legislation a provision that no agreements between the United States and Taiwan will be terminated by the administration without the prior concurrence of either the Congress or the government on Taiwan. Finally, there are a number of important points under U.S. law which are not dealt with in the proposed legislation and which I believe should be included. These include the fact that for no purpose under U.S. law will Taiwan be considered a part of any communist country. Also, that under U.S. law, no communist country will be deemed to have jurisdiction over Taiwan or its citizens or their property, except, of course, to the extent that they might be within that communist country physically at some time. that Taiwan shall have all the attributes of sovereignty, that Taiwan shall have the capacity under U.S. law to contract and to sue and be sued in its own name, and that the courts of the United States shall recognize and enforce the laws and the judgments of the courts of the Republic of China, which is extremely important to have that mechanism for the resolution of disputes if you're going to have an ongoing commercial relationship. Without the provisions that I've just summarized, it will be difficult, if not impossible, to maintain business as usual between the United States and the Republic of China. The prompt enactment of this legislation is not only in the interest of American business in its trade and investment with Taiwan, but is also necessary, I think, to satisfy the moral commitment of our country to the people of Taiwan and to a government which has been our loyal ally. Thank you.